The law matters, and we're here to help you understand it a little bit better, as we say. I'm Deb Moraes, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters because, as we say, the law matters. A better understanding of the law puts you in a better position to decide how to help yourself, your family, and if applicable, your business. As we present various topics, you may decide that you can and will handle some issues yourself. If you decide to enlist professional counsel, you'll be better prepared, and so will the counsel who you select. Our goal has always been to save you time, money, and of course we want you to achieve the best possible results. As always, we want to, yes, again, welcome and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence, who continues to share his legal information, anecdotes, perspectives on all of the topics that we cover. And today's topic is your right to know, navigating, for example, Rhode Island's open government laws. What does that actually mean? And part of that, accessing public records. The goal, of course, here is to educate you, maybe hopefully help increase some civic engagement and also contribute to some transparency. Let's see where we should start. I think at the very basis, this is about what's considered open government. What's open government, David, and why does it matter?
Well, what do they say? Sunshine is the best disinfectant.
That's a great line, David.
Right? So it's really about transparency and being able to have open meetings. If you're a state municipal government entity, you're supposed to follow certain rules. In fact, I believe the Attorney General's office has folks there who specialize in making sure that the open government rules are followed. And then the other side of it, as you mentioned at the beginning, is access to public records. There's a statute on what governments, the courts, the state government, the municipalities have to do when they've given a records request pursuant to that act.
Things are supposed to be done openly. We all know at every level, they're not always, but that's the goal. And the records, the people, the public, is supposed to have access to it. Broad brushstrokes here, David. Why is it that these laws are so important to everyday people?
Because it's the way that we hold government accountable. It's the way that an individual has the right to know what their government is doing. And so the state legislature passed laws which include the Open Government Acts and the access to public records and provide penalties for folks who don't follow those rules.
Was it ever specifically intended that this would also engage people, make them more civic-minded to participate in their local government as a way to also do accountability, checks and balances? Was that an intention originally?
Sure, and it has that effect because a part of the requirements would be posting of meetings and what's going to be on the meeting. So if they didn't have to post meetings, people wouldn't know when the meetings were, potentially. And if they didn't know when the meetings were, they wouldn't attend. So by having a requirement of posting the meetings and posting the agenda, folks have the ability to look at it and say, oh, well, that's a topic I'm interested in. I think I'm going to make sure I attend the meeting.
It's interesting, over the years, whether it was at local or school committee or whatever, there are so many shenanigans that keep these things from happening. Let's explore it a little bit more. So the public meetings first. It's open to public bodies, and who does that mean? Anybody who lives in the school district, in the town, or the state? Anybody?
Anybody.
Anybody.
Anybody. And so it's an interesting thing how some of that works. So the meeting is posted. Folks can go on, for example, I was East Greenwich, the East Greenwich Town Council website. See what meetings are scheduled, see what the agenda is, where it's going to be held, and go. Now, Does that mean every single aspect of what happens at that meeting has to be done in public? The answer to that's no, because a town council, a board, they always have the option to go into executive session. And there are certain rules that cover that.
And of course, we're going to get into that in a few minutes too, but of course that gets challenged on many levels. But let's stay with this for a bit. So you refer to the importance of notice being posted. What does posted actually mean? Does it have to be a flyer on the cork board of my grocery store? Not everybody has or wants to use or rely on the internet. What does that mean to have it posted, David?
So it would be usually in today's world posted on the website of whatever entity it is.
The school committee or the
town?
What does the state do?
Same thing. They have postings of meetings. And, there are different commissions and agencies that will post open access information meetings, agendas. I suppose, I've not looked, but in the town hall, there might be a place where notices are posted. So if you don't want to go on a website, you could go to the town hall and say, when is the well, it wouldn't be in a town hall, but, the historic commission of the town. When are they meeting? And so there might be a posting in the town hall for that as well.
And theoretically, with that posting of the date, time, and place.
And agenda.
That agenda is supposed to be closely adhered to, loosely adhered to, or is that just up for grabs?
Yeah, it's supposed to be adhered to. And there are things in the agenda that might be a little flexible, like a new business, what is that? Someone could raise, well, this is new business, it can be discussed then. It might go back on the agenda as an item the next time, or old business, that type of thing.
So we know there are times when these school committees, town committees, whatever, they can have what's called a closed meeting. Are they ever entitled to do that they're not calling specifically an executive session?
There are certain rules that allow certain types of things to be discussed in closed session, or I would call it executive session, where, say, the town council is discussing a legal matter. You don't have to discuss your legal strategy or have the meeting with your attorney in public view. You can have that, and there might be a summary or something that comes out of the executive session that's referenced, but the actual discussion can be done behind the old closed doors.
I understand too, if it's a personnel matter, that would be one that they might say, we had a personnel matter, but they don't have to say David Bizarre is being brought up on this or that charge or whatever that is. And of course, I'm making that up.
Yes.
No, there's no such thing happening that we know of. When there's going to be an item on an agenda that is likely to be contentious, and there are a lot of them, whether it's about school or districting or new building, what do you as a citizen do to prevent shenanigans? I don't know, that's probably the only word I can think of. So for example, something that's highly contentious in a particular town, the decision is somehow made to hold the meeting in a very, very small building, and all of the proponents of whatever the item is, they pack in, I don't know, an hour before it happens. I think you need 48 hours you have to post. I think that's the rule, but there may be less or more, whatever. But all of the proponents are in an hour before, and there's not even standing room only without it being a fire hazard, which they also use as a ploy. And those who are the detractors don't even have a chance to poke their nose in the room. How do those kinds of things get handled? I mean, it sounds petty, it sounds trite, but it happens. What do you as a good citizen suggest? Or what do you do as a lawyer suggest?
I have been to meetings before where it's been packed like that and people couldn't get in, and somebody from the council in that particular instance, but if it's a commission or whatever, said, we are going to postpone the meeting and move it to an area that has more capacity. So it may have gone from the town council chambers, which maybe had room for 75, to a gymnasium at a school or whatever facility was available that had a much bigger capacity.
So it's those who are running the meeting, it's their responsibility to declare just this isn't feasible, we need a larger venue, or is it the citizens who walk in and say there's no room for me here, we need to postpone? Whose responsibility is it?
The decision's made by the commission, board, or council, whoever is meeting, but there should be input, and you can have input. In fact, most agendas have a place for public comment, and if you feel that there's folks outside who aren't having a chance to hear what's going on, that's the place to raise it and say, I want to talk about the merits of this issue, whatever it might be, but I would ask the council or commission or board to consider postponing this meeting and moving it to a place where everybody can be accommodated. And they'll usually do that.
So one other point about that before we move on, which is the wonders of technology, and there are wonders of technology. Well, we'll just put it, we'll live stream it on Facebook. We have a Facebook page. Does that absolve them from having to, we'll have to adjourn, postpone, or whatever, because theoretically anybody could go to their computer, their phone, or whatever, however they access Facebook to watch that live streaming event. They're not as likely to be heard, but does that also remove the responsibility from the town council or school committee, whatever, for having to postpone it and reschedule it? Does that absolve them?
I'm not as familiar with technology as you, so I don't know if you do have the ability to be heard at public comment from your home, because I believe from what you're saying, it's streaming to you, but I don't think you're streaming back.
So that's part's true, but often someone will be saying, and here I have, and here's a way for you to be part of that, and they will allow you to have your say. But I'm not quite so sure that you are given your fair opportunity if you are one of many hands raised while that's going on, and you say you want to be heard, but you actually might not have that access that you would if you were in the room where it happened.
I like the idea that there's a streaming option for people who can't get there and would not otherwise be able to participate or at least view. But I don't think it answers the question when there's an overflow and people are there that can't get in.
Good point. Okay. So akin to this, but let's shift to the topic about public records. They call it ARPA.
Yeah, ARPA. ARPA. Right? ARPRA. No, APRA.
Access to Public Records Act. Okay, yeah. We got the acronym.
APRA.
What is that about, and why is that important?
Yeah, so a lot of folks want to get records of things that may have happened, or transcripts or something from other meetings or notes of meetings that are available to the public, or in fact, police departments often use that as a way to get records that you're requesting from the police department. So it's a way of accessing public records. And
what kind of documents does that pertain to? Does it mean every email, every report, what other materials that public agency, financials? What is really considered something that should be accessible to the public? Who determines that and how?
Public records, because that's what it is, access to public records by definition. So unless there's something that's protected by some kind of confidentiality, almost all public records are accessible through this act. It can get expensive if you're looking for a pile of information. So my advice would be to narrowly tailor the request. And I've seen situations where even a narrowly tailored request, the response to it from the police department or the commission or the board or whatever it is, has been a little on the onerous side. For example, a client who requested information about him with an interaction with the police department. It wasn't, and with a specific time frame. And he got a bill for 4 hours of research for 4 pages of documents and maybe body cam. And 4 hours to go to the specific date and get those records, that seemed a bit much. There are penalties that the agency or police department could face if they don't follow the rules, because the rules are fairly specifically laid out. How many days they have to respond, do they need more time, what do they have to do to respond? If they don't respond, what are your rights? So there's a lot of teeth to that law.
Teeth.
Only for enforcement.
Yes, only someone has to do it. So I've seen enough of those law kinds of shows, and also read of things over the years where there is
you play a lawyer on TV?
where there's a ploy to just delay, or someone will ask for an onerous amount, whatever, of documents, and rightly so, an agency might say, you've got to be kidding, and this will, I understand they're entitled to charge for it. You were just describing something that's ridiculous, but that happens too. And it's also, they can make it cost prohibitive, or also just delay for who knows how long, which sometimes serves their purpose. When that happens, is it the citizen's right to do something, and what should they do? Or do they really need to have a lawyer call the agency, the whatever in question, on the carpet?
Right. There are times when the request is so broad and burdensome that the agency or the police department or whoever is the information is being requested from is absolutely right to say, this is how long it's going to take us. This is what the charge is going to be. This is how much it's going to be per page or whatever. Because
they quote it?
They quote it. And this is how long it's going to take us because of special circumstance. You're asking for every document that we have, whatever.
Epstein files.
Yeah, well, exactly.
3 million papers or whatever.
Yeah, or 6, depending on who you are. But in any event, yes, a request to the Department of Justice for all, or Rhode Island Department, Attorney General, for all of the files on the Epstein file that you public might have a right to, that would be extremely expensive and burdensome, but it could be done. So the request to a police department for what might amount to 4 pages and shouldn't be 4 hours of research to get those 4 pages in body cam. Maybe it's an hour, maybe it's 2. And then what's the rule say? I think they're supposed to respond within 10 days.
10 days,
And then
yes.
they can ask for an additional 20. But if you're talking like a month or 2 months later and they still haven't responded, or you think that there's some other, as you said, roadblocks they're intentionally trying to throw in, the statute says that they can be sued in superior court. It gives the jurisdiction, and that if they are intentionally throwing roadblocks or they haven't complied with the statute, there can be fines. And if they are found to have intentionally or otherwise not complied with it, you can be awarded attorney's fees.
Good to know. What would it cost for an hour's worth of work? I have no idea. I've never had an occasion to ask. Do you have any idea, David?
Yeah, from like a request from a department.
Yes.
I've seen $45.
Okay.
And I believe, I haven't looked at the statute in a while, but I believe the statute says the first hour might be free. I'm not sure if that's in the statute, if that's what some of the agencies say, we'll do an hour for free. Mm-hmm. But when they quote you 4 hours, no, it's $15 an hour, I think. Yeah, I think the last one I saw was 4 hours, the first hour free, $15 an hour, so it was $45 for the research.
Got it. Thank you for sharing that. I think people should probably know about that. So while we were talking about what is public record, what isn't public record? So for example, if there was something to do with, I don't know, a business's trade secret and it went to court, might that be something that's protected and not likely to be multiple copied and requested as public record? What other kinds of things do you cross your mind?
Personal information that's held in a government records somewhere is generally not public.
Okay.
So when you file in family court, for example, electronically, you're supposed to check off whether something's public record, confidential. So, for example, if it's a juvenile case, all
okay.
of those records are confidential. Those can't be requested.
That's a good point.
Go ahead.
What about law investigations in general? If something is under investigation, is that a public record? Who has the right to request information about
So
that?
you'll often see that an ongoing investigation, when a request is made, they'll say, no, it's an ongoing investigation. We're not going to give you any information.
That sounds right on the one hand, but it also sounds like it could be a ploy to stonewall or something. So
Yeah.
it could happen either way.
That's a balancing act.
Yes.
Between the public getting records or information and giving records or information that would interfere with some agency, let's say the state police or the attorney general, doing their job.
Sounds right. So suppose you request, they deny. There's always a right of appeal, right? Who does that? You as a lawyer or the citizen who's interested, the public who's interested in getting it
If I
done?
were requesting information and I didn't get it, maybe based on our last show, I'd call the Rhode Island Bar Association and get a lawyer referral to an attorney, get my free half hour, ask them what I need to do and determine whether it's something that I could do myself or I want to hire a lawyer to do. But the answer is many agencies will have a process for appealing, an administrative appeal. So if you or the city of Providence and the request was made and it was denied at the agency level in the city, there's a place to appeal a records request in Providence to, and that can be reviewed. And if it's still denied, then you have the right to file in Superior Court asking that the records be released to you.
Superior Court. Some have ombudsman. Would they be like
That's sort of like the person that you're appealing to.
Yes.
In Providence, it's got a certain name. In other places, they might have an ombudsman or somebody.
I've also heard that you can register your complaint with the AG's office. What cases is that just something that's of the state level, David?
The AG's office, like I said, with the open meetings requirements, it has a lawyer that makes sure that cities and towns meet their open requirement meetings. They may, if there's an ongoing situation with a certain agency or town or whatever it might be, where they're routinely denying records, that might be something that they would be interested in. But it's really, wherever it is, the jurisdiction lies within Superior Court. Once you get to past the ombudsman and the agency appeal and the administrative appeal.
Of course, this conversation triggers the thoughts of Providence Journal that has historically acted as a major proponent for open government transparency, open records. And I know that they've done numerous stories on it will cost us thousands of dollars. So that was, I think, probably a ploy. Maybe it wasn't. I can't imagine that the Journal would not have zeroed in on exactly what they want, but have gone through hoops and hoops and appeals, whatever. I know that they keep fighting to have access to...
Didn't they have a records request for all of the DOT information regarding the bridge?
Yes. Did they get it all?
Yeah,
I don't know.
I think so.
I'm not sure.
I think they've done stories based on what they got.
All the time they're doing it, because what I gathered out of all this, their records requests, it's only as good as how well it can be enforced, and they've been at it like pit bulls, obviously. But I know that the paper routinely triggers complaints to the AG's office because of supposed violations. Are they going through appeals process too? They must be going through numerous appeals processes.
And I'm sure that they have their lawyers, when they feel they're being stonewalled or whatever, go to Superior Court and say, there's no reason why we can't have these records now. And remember, there could have been some roadblocks, if you want to call them, but legitimate ones, to say, no, we don't want to release this report right now because we have ongoing litigation, and that's central or key to our litigation. And my recollection is there may have been some argument made for that, but it was released anyway, on one report or another.
So, government accountability, certainly it's necessary, not just in our little state. I assume, or from what I've been reading, Rhode Island is sort of middle of the road, and I think the Sunshine State, as you brought up at the top of the segment, casting sunlight is a good thing. The Sunshine State is known for having the most open of open government, open records, good for them. But we have these ongoing things that the Providence Journal has been writing about for years, and I think other states have had the same thing. If it becomes litigious, it's time consuming, it's energy and resource depleting, it's everything. Is there anything else that can be done short of saying we're going to sue you and then off to the races, even that they're doing it at the national level too, with our own president tying up the Supreme Court and other agencies with disputes and back and forth, and not to be political, just not, but the idea of there being ongoing litigation. Is there anything else that they can do other than just saying we're going to sue you?
Well, you can always, like you said, there's an ombudsman or an agency within a city or town that might hear these kinds of things. I would always recommend trying to resolve it that way first, which you have to anyway. You have to exhaust your administrative remedies. But it seems to me that if you are going to hit a stone wall and you're entitled to the records, at least you think you are, and that's why I would consult with an attorney just to make sure you're not wasting your time. But if you're otherwise entitled to the records, the Attorney General's office or litigation are probably your only two remedies.
Is there any value in the strength in numbers? So let's just bring it back to the very local level. If it's school committee and local government, for example, someone opposes the issue or questions the open records. If they gather a force of citizens, neighbors, friends, whatever, strong proponents or whatever it is, detractors if it's the other side, if there are many of them, can that alone cause enough of a groundswell to make someone reconsider, short of going to lawyers in litigation? Is there strength in numbers? Is there value in that, or is it just you're spinning wheels and wasting time?
There's always value in that for a number of different reasons. Certainly if it's a city or town or a local agency or whatever that is not giving the records, and they see that, well, wait, there's one person requesting it, but there's a whole group of people who are interested. And that will turn heads, and higher ups in the organization might say, why aren't we providing this, and reconsider. But strength in numbers is always a helpful thing.
When we're talking about the open government, open records, as I said at the top of the segment, we're here to help educate, increase awareness, help empower people. Hopefully this kind of discussion, enough people will hear about that when it relates to them, whether it's what's going on with their children in school or something that's at the state level, they feel that they have something that they can do rather than just say, oh, that's too bad, and shrink away from it. It seems like there's much more interest in that these days, maybe because there's a lot more that's contentious. But do you think that we're moving in the right direction, that we've actually gotten better at it because so many people are involved with this these days?
I think the law and the enforcement of the law and just getting information out to the public has really helped improve our ability to know what's going on in our local government.
Thanks, David. We hope this has been helpful to you. It's good for you to be involved, be more civic-minded if you can be, and active when you can be. We thank you for tuning in to The Law Matters. We hope you'll continue to tune in. It matters to you. Thank you.